Let me ask you a very serious question. If you pay GST demand, interest and penalty, or your case is already under adjudication, can you still face criminal prosecutions, even jail? नमस्कार, मैं प्रेम सिन्हा आप सबका स्वागत करता हूं एंड टुडे आई एम गोइंग टू ब्रेक डाउन अ वेरी क्रिटिकल सुप्रीम कोर्ट रूलिंग दैट एवरी टैक्स पेयर मस्ट understand. The judgment in CS Prakash versus C Satyakumar has completely changed how GST prosecution works in India. In GST practice, every one very common defense is the this that sir, this is not a criminal case. This is only a tax dispute. Taxpayers and representative of taxpayers, even advocates, always has seen arguing that it is about classification, it is about ITC eligibility, it is about valuation of issues, it is about interpretation of law, and then they approach High Court under Section 482 of the CPC to quash prosecutions when the prosecutions are launched by the GST departments and even confirmed by the civil court. Then the taxpayer directly approach to the High Court to quash the order using the inherent power of the High Court. But now the Supreme Court has clearly rejected this argument. The Supreme Court, the Honorable Supreme Court in CS Prasad versus Satya Kumar laid down a very powerful doctrine. Honorable Supreme Court said that civil proceedings and criminal proceedings are independent. There is no relation between civil proceedings and criminal proceedings. So let it simplify. Adjudication of tax, interest, penalty is a civil, but prosecution is a criminal liability. The Honorable Court clarified, if civil proceedings are pending or completed or may be decided, criminal prosecutions can still continue if intent of mens rea exists. What the Honorable Court states, criminal prosecutions can still continue if mens rea exists. If your demand had been adjudicated, you have paid the demand, you have paid the interest, but still if there is a economic offence or mens rea intent is existing, then criminal prosecution can still continue. Under goods and services tax, criminal liability arises under section 132 of the CGST Act. This section targets very serious offence of GST involving intent. Which kind of intent? Which attracts section 132? Fake input tax credit, bogus invoices without supply, circular trading, suppression to evade tax, falsified records, and sell companies. These are not compliance mistakes, but these are economic offense as per the Honorable Supreme Court. So the Supreme Court also gave a strict warning that High Court should not convert quashing petitions into mini trials. At section 482 stage, courts should not examine invoices, should not analyze evidences, should not test sufficiency. If allegations show a prima facie offence, trial must proceed. This is extremely important in GST prosecution matters. This ruling is a major boost to GST enforcement. Earlier, accused used to argue, sir, this is the department delay, revenue is neutrality, audit already has been done, tax already been paid, then the prosecution should not be initiated. So Honorable Supreme Court has clearly said that these are not valid grounds for quashing prosecutions. These matters are for trial. So we should, so what our businesses should take away from this, and what professionals should understand by the Honorable Supreme Court judgment, paying GST does not end criminal risk. Adjudication is not equivalent to immunity. If there is a fake ITC cases, then you are in a serious prosecution exposure. Civil dispute argument is no longer a safe defense, especially in cases involving fraud or fake invoicing. Let me conclude with one powerful line: adjudication determines tax, but criminal law determines intent. And in GST, you cannot escape prosecutions by calling it a tax dispute. If you found this useful, then like, share, and subscribe to the channel. This is CS Praveen Sinha bringing a practical legal insight on GST and corporate law. Comment GST 2026 if you want any more video like that. Thank you. Thanks for watching the video till the end. Thank you.